Okay, well, let's start off with putting the prosecution to proof. We come at this from an interesting angle in the sense that if one were to have a look at the head note of Gavin Rochford and what it's about, it was fundamentally an appeal to the Court of Appeal Criminal Division against the finding of contempt in the sense of 28 days. And you think, well, what's that got to do with putting the prosecution to proof? On the face of it, not a lot, but bear with me. Gavin Rochford is an interesting case. In fact, I go so far as to say it's a fascinating case, particularly on the facts, but of course it enunciates and reminds us of a very important principle, which we'll come to in just a few moments. So what was the case of Gavin Rochford all about? Well, and so returning to the case itself, he says, so was the judge right to find that he'd failed to give proper disclosure under the CPIA? And Lord Justice Hughes said that he was not, that the judge at that stage in proceedings was not able to say. He said he was judging the position from a position of ignorance. Okay, of course, if the defendant didn't give evidence, okay, and didn't advance any positive case, then he would not have been in breach of the CPIA. If he'd got into the witness box and said, I wasn't in the van, I was at home alone and not put forward any alibi evidence, then again, he would not have been in breach of the CPIA. However, if he'd said, right, I'm going to give evidence and I'm also calling my girlfriend or my boyfriend or whoever else it might have been that I was with that night to give evidence to say where I wasn't, then of course he would have been in breach of the CPIA because he wouldn't have been given disclosure. We then come to a case of Tinian, which again reminds us of a very simple but important point, which we've touched upon already. Tinian is an important and interesting case, and I'll give you a little bit of a view, my perspective on it for what it's worth. It was a case at Reading Crown Court where Master Tinian had been convicted at Maidenhead Youth Court of dangerous driving. Okay, his defence at trial had been that he was driving in Maidenhead on the day elsewhere with two friends. Okay, he declined in interview to name either of those friends, and he didn't choose to call them either at trial. So no notice given, and didn't call them at trial at Maidenhead Youth Court.